Welcome to Then There's California. It's a podcast featuring members of the California State Senate Democratic Caucus discussing legislative priorities, policy, and other related issues that make California exceptional. From Santa Barbara this time around, I'm Brian Green, and it's 2018, and what an extraordinary year it has been for women across America and here in California. They have successfully, justly seized the moral and legal initiative in challenging the status quo in Hollywood and in the corporate corner office. But it's 2018, and notwithstanding the generations of effort and protest and the small margins of fiscal and legal and even moral victory, the Me Too movement has shown that there is much more change and accountability that needs to happen in that area, and economic or social progress and advantage has not carried enough women in its tide. And that lack of pay equity and equality and agency, yes, even circa 2018, harms women, harms their future, harms their families, and harms the community as a whole. It's been a long fight towards social and pay equity, even here in California, but that fight has some tireless warriors and revolutionaries, particularly in the California State Legislature. Well, my co-host on this edition of Then There's California is one of those warriors, those revolutionaries, who has not backed down from the pay and gender equity fight, and who has actually scored some historic legislative victories in that regard. And her advocacy continues. Senator Hannah-Beth Jackson is a leader in the Legislative Women's Caucus and is the chair of the Senate Judiciary Committee. And she's the author of one of the most historic pieces of pay equity legislation signed into law in this generation. And she's going to talk about that and other gender and pay equity issues with her guest. We are here in her district office here in Santa Barbara as we speak. Senator Hannah-Beth Jackson, welcome to Then There's California.
Well, thank you very much, Brian. I'm delighted to be here and to also be able to interview our guest. We're going to talk about pay equity and the continuing fight against workplace discrimination and harassment with Rabia Rahman, a workers' rights associate attorney with one of my favorite firms, Ventura's Myers, Witters, Gibson, Jones, and Feingold. I think that name continues to expand, but they are very smart to have brought you on board, and Rabia represents individuals and collective actions in wage and hour cases as well as workplace discrimination and harassment. Thank you for being here today.
Thank you for having me.
Well, you know, we have a new generation of women in the workforce that is represented by young women like yourself, and young I define as anyone under 60. And it's really a different time. We have seen society shifting. The workplace has shifted. There are more women in the workplace, both because women want to be and because women have to be. And so on the economics of it all, we are still way behind. When I first started this fight about 35, 40 years ago, women were averaging about 57 cents to every dollar a man was making. We're now up, actually in California over the last year, we're now up to 89 cents, but for white women. When I introduced my equal pay bill back in 2015, we were at 84 cents. So we're jumping up as white women, but women of color are still way, way behind. For African American women, it's about 64 cents to the dollar. And for Latinas, the biggest wage gap, lowest income, is at about 44 cents to the dollar. And this, of course, is a real challenge because women are in the workplace because we need to be. Women, young women in particular, who have families, young men are wanting to participate more in raising their families, but it doesn't seem we're really making that much progress. And I wonder, you as a litigator, what are you seeing as someone who does employment law? What are the biggest challenges that you're seeing in the workforce today, in the law today, to women bursting through that glass ceiling and gaining equity in the workplace?
I'll answer your question in 2 seconds. I just want to say I am so proud to call you my representative, and you certainly serve as a great example for women and advocates. So thank you for all the work that you do. To answer your question about pay equity in the workplace, one thing that I'm definitely seeing as being an inhibitor is the comfort with just talking about it and taking the stigma out of talking about how much we make, what our compensation packages are and our structures, even speaking with amongst professionals and with my friends, like we still are so uncomfortable just talking about it. And so when somebody comes into my office and has a potential sexual harassment case, for example, one of the questions I certainly ask is, let's talk about your pay. If you have a really strong sexual harassment claim, there's probably other things going on in the workplace other than just the harassment with regard to pay equity. And so I kind of dig deep into their compensation structure, and I ask them, what are your colleagues making? What are your counterparts making? And they just have no idea. And they have no kind of facts to support bringing a Fair Pay Act claim because nobody's talking about it. And so I think to help people engage in those conversations, some kind of dialogue intro or something, just to kind of take that stigma away from talking about pay in our compensation structures.
Well, of course, in my legislation, SB 358, the Fair Pay Act, which became law in 2016, and which I am told is now being used as the model or template for fair pay legislation in 41 other states. But as part of that model, not only do we talk about equal pay for what we call substantially similar work, we also have a prohibition against retaliating or discriminating against employees who either disclose or discuss or inquire about their own or their coworkers' wages. That, as you mentioned, has been a real problem. We don't have anything to compare it to. And I think perhaps part of the problem in having that discussion is that for years, it's been made very clear by employers that if you discuss that, if you ask about it, you will be fired. This legislation prohibits that kind of retaliation in order to discourage pay secrecy. So it's very interesting that we still have a ways to go. And of course, that helps me guide when I talk about this, the fact that that prohibition is now very clearly in law. You cannot discriminate. You cannot retaliate if someone asks. So if I ask as a coworker, now you don't have to tell me necessarily because there's a privacy factor here. But if we do want to talk about it, then of course we're free to do so without fear of retribution. Now, of course, you see probably, the law has certain requirements to it. They aren't necessarily followed, and people tend to be somewhat intimidated. Are you finding that? Are you finding that employees tend to be intimidated by the potential impacts of their standing up for themselves, particularly women in the workplace?
Yes, absolutely. And also, part of the genius of the law, the legislation that you passed with regard to the protection from retaliation for discussing your pay in the workplace, it helps us provide guidance to our clients and let them know, like, that act, that engaging that activity and that conversation is protected under the law. But still, there's that social stigma of just kind of disclosing it because it doesn't feel good to know that you're making less than your counterparts, and when you're working as hard and you're giving so much of your life to your employer and to know that they don't value you, right? And a part of what demonstrates your value to your employer is how much they pay you.
Of course.
And if they're paying your male counterparts more, they just don't feel that value. And so having that retaliation aspect built into the law allows us to guide our clients to know that those conversations are protected. You can have those conversations, but there's still that social stigma that that hurdle that they have to get over to engage in that conversation.
Well, women and money is an interesting issue because even in the political world, women have more difficulty asking for contributions, asking for money than their male counterparts. And that is something that I don't know whether we're taught not to ask those questions, that it's impolite, but certainly it is a problem that is prevalent. In fact, the interesting story is I started researching this particular legislation. I've been working on equal pay for about 35 years, so I call the bill my 35-year overnight success. But the Lilly Ledbetter situation, Lilly Ledbetter only learned that she was being unbelievably underpaid relative to her male colleagues who were nowhere near as experienced, qualified, or had the responsibility she did. She learned about it when one of her male colleagues actually put his paycheck on her desk. And that is when she discovered she was not being paid fairly. And, of course, the Supreme Court said, lady, you should have known, or it's 17 years later, too late. And that, of course, was the first bill that Barack Obama signed when it came to being able to litigate that issue. And we have definitely have a long way to go. But like any culture shift. It takes time, it takes information, it takes knowledge. So I'd like to kind of shift over to this whole issue of sexual harassment, the Me Too movement. I go back to the days of Anita Hill, and here we are yet again in that situation. And it is a serious problem. It's raised a lot of consciousness. It has helped women who have been the victims of sexual harassment over the past decades realize that they're not alone. Tell me a little bit about how you go about proceeding with a lawsuit when someone comes in who's been sexually harassed.
There are different ways. But one thing about the Me Too movement and these kind of egregious cases that we're hearing of sexual assault and harassment in the workplace, people see these horrible stories, these horrible examples, right? That is the standard by which they measure sexual harassment. And so when you have like a less egregious experience of sexual harassment in the workplace, people are less inclined to take it seriously. And I think that may be one of our biggest inhibitors to working towards a sexual harassment-free workplace, is because the smaller, everyday experiences that women experience are no longer looked at as valid in the minds of some because they're not egregious examples, which is also, again, some of the genius in your legislation that you introduced this year with regard to providing guidance to courts to interpret the severe and pervasive standard. So, I mean, I think that will definitely help in that regard. But with me proceeding with the sexual harassment claim, standard statute of limitations is the first question. When was, the last act, or when can we kind of tie it back to in order to establish a statute of limitations, make sure we get our DFEH right to sue letter on in time. So hopefully we get that extended as well, statute of limitations, because it takes so much out of a person to have been harassed and to be devalued and minimized in the workplace. And so to come forward, if you come forward within a year, I think that's extraordinary. So we can definitely, hopefully we can get the statute of limitations increased. But that's the first question, is when did this happen? So we can get our right to sue letter filed.
There are a number of hoops that you have to go through to bring one of these claims. Mm-hmm. It isn't like people are running to the courthouse steps. Yeah. You have to submit a claim to the Department of Fair Employment and Housing. They will investigate, either give you a right to sue letter, or they will take charge of the issue and try to mediate it, resolve it. And it's not an easy process. People there are major obstacles to overcome in bringing one of these claims. You have to really have the fortitude to proceed.
Exactly. After we get the right to sue letter, then you have to sit down and have a serious conversation with your client, because they're still healing. It's not like they are healed and you're ready to fight. I mean, because they're still healing from that harm. And so you have to say, you're going to be reliving this experience for the next year or two minimum, through discovery, through depositions, and if we proceed to trial. So yes, you have to have that conversation with your client. Let them know, are you prepared to relive this moment for the next year or two?
And one of the things you said that I think is really important, and that my legislation, SB 1300, tries to address, is the standard in the law for sexual harassment is that the behavior has to be severe or pervasive. Mm-hmm. So what does that mean? And what we've tried to do in this legislation is to give guidance to the courts. There was an example, and we had a woman come and testify before a hearing that I conducted in my position as chair of the Judiciary Committee and also as chair of the Select Committee on Women, Work, and Families. Mm-hmm. Talked about an experience she had, I think it was in the city of San Mateo, where she was working as a 9/11 operator and was answering a 911 call. And one of her male colleagues came up behind her and shoved his hand down her blouse and started fondling her breasts. And when she complained about it, she was told, oh, forget it. It's just, boys will be boys. Let it go. And then she sued. And the case went before the federal courts, and I'm not quite sure why it was in federal court. But the judges said, well, it wasn't pervasive and it really wasn't severe. Mm-hmm. And, of course, that is an example of some really outrageous behavior. I haven't met a woman yet who didn't say, are you kidding? And most men agree. But these judges, it was a 3-judge panel, decided that was not severe. And so part of this legislation tries to define what severe or pervasive is and talks about the fact that Sexual harassment is a violation of your civil rights. The right to give your best work at your job. If behavior impacts your ability to do your job, that is sexual harassment. Now, is that something that you have been able to present in litigation? Is that something where the courts have been responsive or juries have been responsive? What is it in your experience that it takes for the courts to find that this behavior is unlawful and a violation of the Civil Rights Act?
Well, I will tell you, I have not yet had my first trial in sexual harassment yet. I want to go to trial on one of these cases.
Do they tend to settle? Or?
They always settle because it takes a lot to withstand a motion for summary judgment of Fair Employment Housing Act cases.
Why is that?
Because it's fact-based, right? And so with wage and hour, it's labor code violations. It's usually right there on the paycheck stubs, and it's objective. You can see it, right? But with discrimination, harassment in the workplace, it's fact-based. And so you have witnesses and who's credible, and you're looking at the stories and what supporting evidence you have, and a lot of it is subjective. And so it's one word against another. So yes, you have to have substantiating evidence to withstand a motion for summary judgment on a Fair Employment Housing Act claim. So when you proceed, you usually have evidence to substantiate what your client is saying. And when you do, the insurance company sees it and
boom,
forces the employer to settle. Even if the employer wants to say that they didn't do anything wrong, which, obviously we can prove that they did or failed to act in some way, then the insurance company says, we know this is going to resolve against you, and so we want to kind of settle it and mitigate the potential amount they have to pay out.
So actually part of this bill also urges the courts not to make decisions based upon motions for summary judgment because it is important to be able to evaluate the credibility of witnesses, and what may seem like minor nothing, like you come to work and there's one employee who every day makes some crack about the way you're dressed or you're too fat or something that impacts your sense of confidence and well-being and has a sexual nature to it, because frankly today still most judges are male. And summary judgment motions are for the court to determine. So this bill also does discourage these decisions to be made before a fact finder or jury can evaluate all the evidence in its totality.
Also, arbitration agreements. Right. And so when you're forced into arbitration, you sign an arbitration agreement as a condition of employment, then you don't have the ability to have your case tried in court. So it's another reason why we're not, well, me personally, I'm not getting to trial.
And there is now also a bill before the governor that will prohibit mandatory arbitration agreements as a condition of employment. We'll see what happens there.
Fingers crossed.
You're listening to Then There's California. We are discussing gender and pay equity issues with State Senator Hannah-Beth Jackson. We're at the district office of Senator Jackson here in beautiful downtown Santa Barbara. My name is Brian Green, and also joining us is Rabia Rahman. She is an associate counsel, a workers' rights attorney based in Ventura County. And Rabia, as we continue discussion about these gender and pay equity issues and their impact here in California, not to mention nationwide, you are a graduate of UC Berkeley Law School, and several years ago you were actually one of the signatories, you and I would say hundreds of other UC Berkeley Law alumni, on a letter sent to the president of UC Berkeley demanding resignation or at least action taken against the dean of the law school at that time, who had been accused of some behavior and sexual improprieties. And so as we discuss gender and pay equity issues and sexual harassment issues in the workplace, there's also the issue of sexual harassment within the education community, particularly the higher education community. Do you want to reflect on that a little bit?
So that particular situation happened after I had left. I signed on as an alumni.
You've been gone for a couple of years.
Yeah, and so I signed on as an alumni to support his resignation because he wasn't leaving on his own. But yes, you're absolutely right. And I think until we see an increase in women in position of power and authority in the workplace, whether it be at an institution of higher education or more female elected officials, and seeing women in those positions of power and authority, we're not going to advance this movement. I mean, I don't see how without increasing the ranks on boards of corporations.
I was just going to go there. Yes, indeed.
What a great segue.
It's so necessary. It's to see women in judicial roles and appointments, to see women on boards and corporations, CEOs, partners at law firms. My personal experience with the Fair Pay Act is seeing these major law firms being sued for violating in the Fair Pay Act and not paying their associates and partners on par with their male colleagues. And so, I mean, I think seeing more women in those roles in academia and tenured professors will definitely help that.
We are seeing more and more women who are taking leadership positions at major universities. And lo and behold, we can do the job. It's kind of amazing. And so that does raise legislation, SB 826, that will require California's publicly traded corporations, which are based here in California. Most corporations are incorporated in Delaware because they have no requirements or anything. But when their home base is here in California, it's going to require that they add women to their boards. And the data is very clear that corporations where women make up a critical mass outperform those that don't. So in other words, we see that when you have a critical mass of women, usually defined as 3 or more in a board of 6 or more, you see the companies are more profitable, they're more productive, they're more innovative, they're risk averse, so their debt ratio is less, their governance is more transparent, and they're more worker friendly. And this, I think, is a critical issue as more women come into the workforce. But the boardroom has been the last bastion of male domination. My staff hates it when I refer to it as the man cave, but it really is. It's a place where the guys don't want to share that power. They like to choose people they're comfortable with. Yeah. And yet we see when women enter the boardroom, when women enter academia, and law firms and other entities in the political arena, there's a major change. And of course in the courts. So in your experience, have you found that working with female judges has been, especially in employment issues, they've been more receptive, or have you found it to be sort of gender blind?
Well, if you look at our courts in Ventura County, they're increasing in diversity, but all the civil assignments are all men. So I have not had that experience yet, unfortunately. So when I do, I promise I will give you a call and let you know. But to that point you just made about women in the boardroom, I had the opportunity to attend a conference at Berkeley Law not too long ago about the globalization of the Me Too movement. And we got into the conversation about there's pushback against the Me Too movement and bringing forward multiple allegations of sexual harassment and assault against high-powered individuals and major figures in society. And people are really worried about, we got to worry about, the bringing that particular male down, and because they're job creators and innovators and they create other opportunities for women that may be no longer available if they're not there to create the position. And so I said we have to stop that false narrative. It's not that they are the only ones capable of doing the job. They are the only ones. I mean, they have been preventing women from engaging in those positions and those opportunities and accessing that work and those roles. And so we have to stop progressing this false narrative that only these men who engage in this horrible behavior are capable of leading. And so that was my response to that kind of pushback.
Well, I think that's critically important, too. And, this sexual harassment by these men in positions of power is pervasive. And, in fact, I did legislation that expands the definition of what sexual harassment is in relationships that aren't necessarily direct employer-employee. We have the Unruh Civil Rights Act, which establishes civil liability for a number of things, including sexual harassment in business, service, or professional relationships. And as a result of some of the publicity on the Harvey Weinstein situation and, Matt Lauer and all of these folks in the entertainment world, as well as up in the Silicon Valley, I added to the specific items where this kind of behavior is violative, when there's this power display where sexual harassment occurs, is also to add investor, So investor, entrepreneur, and we saw that story with Ellen Powell, I think her name was.
From Kleiner Perkins, the
from
venture
Kleiner
capital
Perkins,
firm.
although she lost her case, I think had this law been in effect, she sort of was the beginning of this recent cresting of the Me Too movement, but she certainly had quite a story to tell. So we've added the investor-entrepreneur relationship. Elected officials, certainly Sacramento, Washington, D.C., the halls of power throughout the country have not been immune from this behavior. We included lobbyists who I learned have taken enormous liberties with those who are either employees in legislative offices or with some of my female colleagues who are legislators. Directors, producers in the Hollywood arena, hearing some of the stories from Mira Sorvino. I remember Christine Latte was sharing some of her experiences, and so many women in that world. We had some women came before our committee, gave it compelling, embarrassing testimony. It should have been embarrassing to the men. But for some reason, we as women seem to take on a sense of responsibility for this awful behavior that men impose upon us. And it's my hope that as we move forward with this, whether it's legislatively, whether it's through lawsuits and what have you, that this behavior stops. And I think what's critical, and I'm hoping that what the Me Too movement will have accomplished, if nothing else, is to help change that behavior. It's not okay. It's not going to be acceptable going forward. And you're not going to get to use your power to intimidate, embarrass, humiliate, degrade women.
Yeah.
I wonder what your thoughts are.
I think with regard to those power dynamics and those relationships, I think what was difficult for like sexual harassment cases in those kind of power dynamics is the concept of unwantedness. Like in order for it to be actionable, it has to be unwanted sexual advances. And so when you're in that kind of power role and power dynamic, the perpetrator, will argue this was mutual. Like they were participating. They gave no indication that this was not acceptable to them or was not welcome. And the woman's perspective is, I was cringing. I felt demeaned. I felt mortified. And so there's this weird interplay between the power dynamic and the unwantedness.
Right.
And also just the sheer shame factor of feeling so demeaned. And what do you do? I am a professional. What do you mean? How do you feel so entitled to treat me this way or to engage in this behavior? And then you start to self-doubt. What did I do? Maybe I did lead him on. Maybe I did make him feel like it was wanted. And you have to navigate this weird internal struggle and this internal conversation. And when you put that power dynamic into it, it makes it all the more difficult to navigate.
Right. Well, again, a lot of this, from the way I look at it, is just changing the culture. Back a few years ago, within our then Senate Pro Tem, we did legislation that is today referred to as the Yes Means Yes legislation on our college campuses, affirmative consent, and recognizing that we need to treat each other with more respect. And when you look at that, we are not just objects of male sexual gratification. And that is a kind of a shift, a significant shift in what, unfortunately, I think has been our culture, perhaps since the beginning of time. I think of the TV show Mad Men. As an example. And women are fighting back. What we're saying is, this is not right. And I will I should not be demeaned, but I will not be demeaned. And frankly, I think seeing more women in positions of leadership, we now have the first woman pro tem leader of the Senate, the California State Senate here, this very progressive state. For the first time in 2017, we elected a woman who then became our pro tem, I think, in February or March of this year, who is also, by the way, openly LGBTQ. And so what we're seeing now and where I hope we are going to be going is, whether it's in the courthouse, whether it's in halls of power, whether it's the President of the United States, and God knows, the bar is so low now, I don't want to hear anybody say women aren't qualified for this job. Whether it's our boardrooms, whether it's in the entertainment world, we want to be treated with respect and dignity, and the jobs that we get should be based upon our skills and our qualifications. So I'm hoping, again, in your generation and seeing more women in leadership roles, whether it's as attorneys fighting the fight. And my hope, too, is that men will start shifting that dialogue as well, as both mothers and fathers start setting a better and a different example for their sons and their daughters.
I'm really glad you mentioned that, because I was thinking as well, like, we can't forget our male counterparts. And back to your legislation and bystander training, it's such a heavy burden for women to always carry, being the victims as well as the people who are progressing these issues. And so we need men to step up and shoulder that for just a moment. We'll pick it back up, but we need you to step up and to be an ally and to know that we're better when we're in it together.
No question about it.
Yeah.
And again, part of this too, we're seeing a change in the work culture. We're seeing more young men want to participate in the rearing of their children. And so I did legislation last year, SB 63, which provides up to 12 weeks of job-protected maternity and paternity leave for more California employees. And as we start sharing the workplace, as we start sharing our incomes, as we start sharing the raising of our children, as men start to experience the challenges of raising kids, they become more appreciative. Men don't go home now to babysit their children. The notion that you used to applaud a man who decided to be home in time to read a book to their kids at night before they went to sleep. These were extraordinary gifts, quote unquote, that men were giving their children. Today's men are stepping forward saying, you know what? It's soccer. I'm the soccer coach. I need to leave work early. I've got a newborn. I need to be at home caring for my newborn. That is going to help change the culture and create greater equity, and certainly this legislation that is now law is, I think, one way that we can say to our male colleagues, we're all in this together. This is no longer Ozzie and Harriet or Father Knows Best era. We're all in this together. It's going to take time. Culture shifts don't happen overnight, but we need people like you in the legal arena to threaten those who are unwilling to step up with legal action. But on the other hand, I think you mentioned at some point when we were talking, the notion of collaboration, mediation. Is that a role that you see for professional women such as yourself going forward?
Yeah. It's actually really interesting. So in order to mediate, you have to propose mediators to your opposing counsel. And I always propose female mediators, and my male counterparts, they don't accept them. So I think for female mediators, it might be another gender bias issue. That's the next fight because we need to start demanding female mediators, because there are women mediators, and I think that they're great assets to mediating a sexual harassment.
Facilitators, yeah.
And they are not getting the same shake as the male counterparts. And I'm noticing, I'm thinking about it right now as I'm saying it, but it's so true. They almost always are never selected or stricken from the mediators list.
It's in part, too, because, we tend to value male attributes, generalized male attributes more than female. For example, strength is of greater value than someone who is collaborative. There are qualities that women have. Once we start valuing those qualities, we will see, I suspect, more women mediators, because women do tend to sort of help to lessen that sense of competition and testosterone, if you will. But you're right, we still have a long way to go. The notion that we've never had a woman president of the United States, nor have we ever had a woman governor of the state of California. The farm team is very strong now. It's very strong now when it comes to corporate boards. It's very strong on the bench. It's very strong in education. Now more women are graduating college than men. We've just got to break those preconceived notions. And again, it will take time. But as you say, we need our women and men to teach their children, their boys and their girls, about the benefits of equality and mutual respect. And this is something, hopefully this, legislation reflects policy. But hopefully with this legislation, we will come to that point where we are starting to really shift the culture. And we need women like you in the legal profession to help push that along with the exclamation mark of the threat of litigation. But that isn't the goal. The goal is to get people to work more collaboratively and respectfully and have just equality where we judge people by the content of their character rather than by their gender or the color of their skin or their nation of origin, and hopefully we'll get there someday.
I got to tell you, as the white male sitting here in the room, this program's not about me, but I got to tell you how exhilarating this is to be part of this conversation. It's wonderful. So thank you so much for it. I want to ask you, just to take us out with here, about your past. From what I understand, you were homeschooled. You didn't go to public schools. Education was not a priority, I guess, in your family, even though you did wind up obviously going to college and getting a law degree. You originally wanted to be an immigrant rights attorney, and now here you are doing workplace issues and law. Tell me just about that path to where you are right now.
Yeah. So my parents converted to Islam in the 70s, and so when I was born Muslim and into a very conservative interpretation of the religion. And so the girls were not allowed to go to school, and we were all homeschooled. And my goal in life was to get married and be a good wife. I even went to finishing school when I wasn't married by 18. My oldest sister was married when she was 16. My middle sister was married when she was 17. And when I turned 18 and I wasn't married, what was wrong with me? So I went to finishing school to learn how to cook and clean and be a good wife. This is all in America, by the way.
Yeah.
This is not, it was a really bizarre upbringing. I call it living on the fringe. And so finally, my mom decided that it was no longer a good fit for us in the community because she did want me to go to school. And so we left the community, and that's when I enrolled in Fresno City College. And still having no real goals or aspirations, just wanted to work on just getting through my 2 years of community college. And then I started to excel and meet extraordinary people and women to kind of help guide me through. And without those mentors, I would have had no idea which path to take and where to go. And so then I ended up transferring into UCLA. And again, angels from the sky fall out and give me just extraordinary advice and guidance. And then I do pretty well at UCLA and get into Berkeley Law. And I think at this point, this was my goal. I just need to get to law school now. But then so I graduated from law school, I'm like, what do I do now? And you're right, I was very interested in international human rights law. I spent some time in Egypt working with a refugee organization, so when developing countries don't have the infrastructure to receive asylum seekers, the UNHCR steps in, and the United Nations High Commissioner of Refugees steps in and provides that service, and they decide who can obtain refugee status. But the refugees still are not permanently there in those urban environments. They are then resettled to a third country. And so when the UNHCR is no longer the advocate, they need organizations to step in and be the advocates for the refugees or the asylum seekers. And that's what I was. I was a refugee advocate. But I also had the great fortune of working with the most at-risk refugees because our organization had a direct access to the U.S. resettlement program. And so when we had individuals who couldn't wait those 2 years, who needed to have their cases heard as soon as possible, we got to refer them directly to the U.S. And so these are the people who are most at risk in these urban environments. And it's heartbreaking work. And I obviously have my own demons to wrestle with, and it just was not conducive to my personal development. And so I was like, I don't have the constitution, I don't have the ability to do this work. And which is why I was so fortunate to find employment law, because I get to be an advocate and I still get to help people on a day-to-day basis without those extraordinary potential consequences, right? If I get it wrong, it may just be, it's dollars and cents. It's not somebody's life and liberty. And so I wasn't able to shoulder that risk. And I am running full speed ahead and being that threat to discrimination in the workplace, because I think the workplace is definitely a microcosm of what's happening in society. And when we see it in society, you have to know what's happening in the workplace.
Thank you for being the threat you are. Thank you for driving up the coast and putting this all together.
I'm
and being part
honored
of this.
for you to
I really
have
can't think of a
me.
better guest that we could have had here today. And Senator, it is great to have you spend the time with me on this program and to hear your perspective. As always, having known you as long as I have, it's just wonderful to see you still out there walking the walk. So thank you so much for being part of this
Yeah.
and hosting us here in this beautiful Santa Barbara.
It's a tough place to live, but somebody's got to do it.
And once again, Rabia Rahman, she is an associate counsel, a workers' rights attorney based in Ventura County. That closes our discussion this time around. Then There's California is a production of the California State Senate Democratic Caucus with technical and production assistance from Martin Ashley and Brian Shadden and Rainier Savidiano from beautiful downtown Santa Barbara, California. I am Brian Green.
And I'm State Senator Hannah-Beth Jackson from Santa Barbara. Thanks for listening to Then There's California. 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 California.